Namaste class. Good morning. I am Dr. Rohit Kumar, your academic counselor, Indira Gandhi National Open University. I teach you a paper BPSC 132 Indian Government and Politics. In previous class, we will discuss about Block 2. And Block 2, there are three units in under Block 2, unit number 7, 8, and 9. Unit number 7 completed in previous class, name is legislature. And unit number 8 did not complete it in previous class. Firstly, we will complete this unit and then we come to unit number 9, judiciary. We start with unit number 8 and we start with power of president. Start with power of president. Basically, we will discuss about emergency power in previous class. Now we will discuss about emergency power. With the intention of safeguarding the sovereignty, independence, and integrity of Union of India, the Constitution bestows emergency power on the President of India. The President is empowered to declare three types of emergencies. First, national emergency arising out of the war, external aggressions, or armed rebellion. Second one is emergency arising due to the backdown of the constitutional machinery in the states. And third one is financial emergency. The president can make a proclamations of national emergency at the time if he is assured that the security of any part of India threatened by war, external aggressions, or armed rebellions. This proclamation must be submitted to the Parliament for its consideration and approval. It must be accepted within 1 month by both the houses of Parliament by two-thirds of members present and voting. If the Parliament fails to approve the proclamations bill, it ceases to operate. If approved, it can continue for a period of 6 months. However, it can continue for any legal of time if the president approves the proclamations for every 6 months. The parliament, however, has the power to revoke the emergency at any time by a resolutions proposed by the least one-tenth of the total members of Lok Sabha and accepted by the simple majority of the members present and voting. National emergency under Article 352 352 was proclaimed for the first time in 1962 when the Chinese aggressions took place. The second proclamation was made in 1971 during the Bangladesh Liberation War. On 25 June 1975, for the first time, the President proclamation on the advice of Prime Minister's emergency is the name of grave danger to internal security. According to Article 356, the President can impose emergency in a state when there is a breakdown of the constitutional machinery. However, impositions of president's rule in a state has become more difficult after the Supreme Court verdict in case known as Bomaya case. According to this case, the president can dismiss a state government only after the approval of the proclamations by the both houses of parliament. If both houses of parliament do not approve the proclamation, it lapses and at the end of 2 months and the dismissed government in revived. In the case in 1989, 19 letters from Council of Ministers were sent to the governor of the state, basically Karnataka, for withdrawing support from the ruling party under the SR Bombaya leadership as chief minister. Following this, the governor dismissed the Bombaya government, but within a short period, the defected MLS promised to support back the Mumbai government, but the governor did not give an opportunity to Bombay to produce his majority on his floor of house. The governors dismissed the government on the plea that the chief minister lost majority in the house. Bombaya challenged the governor's decision in the Supreme Court. The Supreme Court gave it verdict in 1994. The proclamations of this type of emergency popularly called as president rule, which can remain in force for a period of 6 months. By the 44th Amendment, the Parliament can extend the duration of the state emergency for a period of 6 months at one instance. Ordinarily, the total period of such emergency cannot be exceeded 1 year unless there is a national emergency in force. However, the total periods of state emergency cannot go beyond their 3 years. The president can impose financial emergency. Article 360 states that if the president is satisfied that a situation has arisen where the financial stability or credit of India or any part of the country is threatened, he may declare a financial emergency. Like the national emergency, such as proclamation has to be laid before the parliament for its approval. On its face value, one can say that the president enjoys formidable powers in reality. However, he can exercise his power only on the aid and advice of the Council of Ministers, headed by the Prime Minister, basically PM. In this respect, the president's position is more like that of British monarch rather than that of President of the United States of America. While the President of India may be the head of the state, the head of the government is the PM, the Prime Minister. Basically, he is the executive power. He is the main executive power in the hand of Prime Minister. He is the real person to utilize the executive power in India. Supreme leader of Council of Minister. Basically, formally, uh, uh, formally president, and informally we can say prime minister. The real executive power under the constitution rests within the Union Council of Ministers with the prime minister as its head. The president is obliged to act according to the advice of the Council of Ministers, which is responsible in the real sense of the term, not to the president but the Lok Sabha. As it Britain, the Prime Minister in India is usually a member of the lower house of parliament. When Indira Gandhi was selected as a Prime Minister in 1966, she was a member of Rajya Sabha. By getting elected to the Lok Sabha, she strengthened the conventions of Prime Minister being a member of lower house. The Prime Minister is appointed by the President. However, the President has hardly any choice in selecting the Prime Minister. He can only invite the leader of the party in majority in Lok Sabha or a person who is in a position to earn the confidence of majority in the House. The Prime Minister holds office during the pleasure of the President. The pleasure of the President in his regard is related to the unwavering majority support which a Prime Minister receive in Lok Sabha. The President appoints the other members of the Council of Ministers on this advice of the Prime Minister. A minister may be chosen from either house and has a right to speak and take part in the proceedings of the other house, though he can vote only in the house to which he belongs. Even a person who is a member of either house of parliament and can be appointed as a minister, but he has to qualify for it by being elected or nominated to either house within a period of 6 months. Now, moving on to the counseling of minister and the cabinet. What is the major difference between counseling of minister and the cabinet we discussed? The term cabinet is used interchangeably with that of counseling of ministers, but they are different. The counseling of minister or the ministry consists of different categories of ministers. At the time of independence, there are no such institution as a cabinet in India. What exists? Then was the Executive Council. On 15th August 1947, the Executive Council was transformed into a ministry or Council of Minister who is responsible to the Parliament. The term cabinet was used thereafter as the alternative to the Council of Ministers. At the state, all the members of the ministry or the cabinet expert except the prime minister had the same status. But the situation changed once junior ministers were appointed to the Council of Ministers in 1950 based on the recommendation of the Gopal Swami Ayanagar reports. In 1950, based on the recommendation of the Gopal Swami Ayanagar report, a three-tier system of the ministry was established, with the cabinet minister at the top, minister of state as the middle, and deputy minister in the lower. Basically, in 1950, based on recommendation of Gopal Swami report, a three-tier system of ministry has established within the cabinet minister at the top, basically ministry of cabinet minister at the top and middle way, ministry of the state at the middle, and deputy minister in the lower rank. The cabinet composed of the senior most ministers whose responsibility transcends departmental boundaries into the entire field of administration in a smaller body and the most powerful body in the government. The cabinet serves three major functions. It is the body which determines government policy for presentation to the parliament. It is responsible for implementing government policies. It carries out interdepartmental coordinations and cooperation. The cabinet meets regularly at it. It is a decision-making body. It is assessed by the cabinet secretariat, headed by a senior member of the civil services, the cabinet secretary, to manage the volumes and complexity of work that comes before it. The cabinet members have developed standing and ad hoc committees. There are four standing committees which are permanent in nature. There are the Defense Committee, Economic Committee, Administrative Organization Committee, and Parliamentary and Legal Affairs Committee. Basically, there are four committees related to Parliament, and they in nature, in the nature, his nature is this nature is permanent in nature. Number one is Defense Committee, Economic Committee, Administrative Organization Committee, and fourth one is Parliamentary and Legal Affairs Committee. Ad hoc committees are constituted for time to time. Next in rank, rank are the Minister of State who hold independent charge of individual ministry and perform the same function and exercise the same powers as a cabinet ministers. The only difference between a minister of state and a cabinet minister is that she is not a member of the cabinet, but attends cabinet meetings only when a special invitation to do in connection with the subject that he is given charge of. There are other ministers of state who work directly under cabinet ministers. At the bottom of the hierarchy are the deputy ministers who do not have specific administration responsibility. However, their duty includes answering the question in parliament of behalf of the ministers concerned and helping to pilot bills. Second one is explaining policies and program to the general public and maintaining relations with members of parliament, political party, and the press. Third one is undertaking special study or investigations or particular problems which may be assigned to them by a particular ministry. From the above, it is clear that the cabinet is the nucleus of the cabinet of ministers, precisely because of the reason Walter Bergerhort calls the cabinet is the greatest committee of the legislature. It is the connecting link between the executive and legislative power. Comes before it, the cabinet members have developed standing and ad hoc committees. There are four standing committees: collective responsibility. The Council of Ministers function on the principle of collective responsibility. Under the principle, all ministers are equally responsible for each and every act of government that is under the collective leadership. Each ministry accepts and agrees to share responsibility for all decisions of the cabinet. Basically, doubts and disagreements and confined to the privacy of the cabinet room. Once a decision has been taken, it has to be loyalty, supported, and considered as the decision of the whole government. If any member of the Council of Ministers is unable to support government policy in the parliament or the country at large, that member is morally bound to resign from the cabinet of Council of Ministers. Even if the Council of Ministers is formed as a result of coalitions of various political parties, a minimum common programs becomes essential for maintaining the solidarity of the ministers, and the various political parties forming the collective government had to stand behind the program. Unless they do so, the cabinet cannot survive. Unity within Council of Ministers is not only essential for its very survival but also necessary for its efficiency and efficiency. And it is necessary to enjoy the confidence of the people upon bickering between members of the Janta government on matters of public policy was the prelude to the collapse of the government in 1979. The cabinet and the parliament. The core of the parliament government is the accountability of the prime minister and the cabinet to the parliament. The parliament does not govern but critically examines the policies and acts of the government and approves or disapproves of them as the representative of the people. The very existence and survival of the prime minister and the council of ministers depends upon the support they receive in the parliament. As we observed, the Council of Ministers is collectively responsible to the Parliament. Thus, the general feeling is that the Parliament controls the executive, but in reality, the Prime Minister, with his majority support, controls the very working of the Parliament. Source of Prime Minister's power and influence through the Constitution does not enumerate the powers and function of the Prime Minister. In practice, she enjoyed a wide range of powers as a leader of the Council of Ministers and the Lok Sabha. The Prime Minister's prerogatives of reconstituting and refunding the ministry as well as chairing the meetings vest the office with considerable influence over the members of parliament. For example, India's first Prime Minister Jawaharlal Nehru could not ignore Sardar Patel, who was very powerful in the Congress party. He was therefore appointed as the Deputy Minister and Home Minister. Some of Patel's followers were also made members of the Lok Sabha. The Prime Minister has enormous control over parliamentary activities. She advised the President on summoning and prorogating of the session of Parliament. This speaker consult the Prime Minister in finalizing the agenda of Lok Sabha. The Prime Minister enjoys enormous legislative power in the form of recommendation ordinance to the President for promulgations when the Parliament is not in the session. But the most important power of the PM regarding Parliament is it to recommend dissolutions of Lok Sabha. The president has to accept the advice of the prime minister. It is the power by which the prime minister controls even the opposition. As the head of the government, the prime minister enjoys the power of patronage. All the major appointments of the central government are made by the prime ministers in the name of president, which includes chief minister and judge of the Supreme Court and High Courts, the Attorney General, the chiefs of the army, the navy, and the air force, governors, ambassadors, high commissioners, chief and members of the election commissions, etc. Further, the prime minister control over the administration, including the intelligence agencies and other administrative wings of the government, enhance her influence over other members of parliament and administration. Apart from these structural factors, there are other features that increase the power and authority of the Prime Minister. In several instances, the general election is the most democratic system. Virtually become an election of the leader, and it is interpreted as a popular mandate. Sometime a leader drives through strength from his charisma. Jawaharlal Nehru, Indira Gandhi, and Narendra Modi present example of charismatic leaders. The President and the Prime Minister. Article 78 enumerates the duties of Prime Minister. The Prime Minister is to communicate to the President all decision of the Council of Ministers related to the administration of the affairs of the Union and proposals for legislation. B. Furnish such information related to the administration of the affairs of the Union and proposal for legislation as the President may call for. And C. It is the President who requires to submit for the consideration of the Council of Ministers any matter on which a decisions have been taken by a minister but which has not been considered by the Council. These duties of the Prime Minister seems to suggest that the President is the real executive with the vast power, but was as we saw, the President can exercise his powers only with the aid and advice of the Council of Ministers. The Prime Minister, heading the Council of Ministers, is therefore the real executive. However, there have been occasions when the President and difference of opinion with the Prime Minister on the policies of the government. The first President of India, Rajendra Prasad, tried to break from the British convention that the head of the state is always bound by the advice of the Prime Minister and the cabinet. In 1987, President Jail Singh withheld his assent to the Indian Postal Bill despite its having been passed by the both houses of parliament. This was a reflection of differences between the president and the prime minister Rajiv Gandhi. Let's sum up. Following the patterns of Following the patterns of British Westminster model, India involves in system of the parliamentary form of government in which the executive is responsible to the legislature. The executive power of the government of India is vested in the President of India, who is both the formal head of the state and the symbol of the nation. The president is endowed with authority and dignity without adequate powers. The president can exercise her authority only with the aid and advice of the Council of Ministers headed by the Prime Minister. It is the Prime Minister who exercises real executive power in the Indian political system as the head of the Council of Ministers. The leaders of the majority party in the Lok Sabha and often the leader of parliament. The president enjoys considerable power and authority through the Prime Minister is appointed by the president and holds office during the pleasure of the president. The Prime Minister is the reality responsibility to the Parliament. The Council of Ministers and the informal cabinet headed by the Prime Minister work on the principle of collective responsibility. Sometimes here have been difference between the President and Prime Minister, but these did not assume serious proportions culminating in any constitutional crisis. Now moving on to and start the unit number 9 judiciary. There are some objectives related to this unit. After going through this unit, you will be able to discuss and know about what is judiciary. Number one is trace the evolutions of judicial system in India. Second one is describe the compositions of the courts in India. Third one, explain the function and jurisdictions of the Supreme Court, the High Court, and the subordinate courts. Fourth is explain the concept of judicial review and its importance in safeguarding fundamental rights. Now, moving on to introduction and discuss in the political system based on constitutional government, the function of the rule making, rule enforcement, and rule interpretation are separated into the three institutions: the legislature, executive, and judiciary. A judiciary that is independent of and acting as a check on the arbitrary exercises of legislative, and executive power in an essential feature of constitutional government. The judiciary is also the final arbiter of what the constitution itself means. In a federal system, the judiciary also serves a tribunal for the final determinations of disputes between the union and its constituents units. Give the tremendous importance of role and function of the Supreme Court and the High Court, and various measures have been adopted to ensure the independence of the judiciary. Now, discuss on evolutions of judiciary in India. In evolutions of the contemporary judiciary in India can be traced to the colonial periods. It was with the Regulating Act of 1773 that the first Supreme Court came into existence in India. Located in Calcutta, the Supreme Court consists of Chief Justice and three judges. Subsequently, it was reduced to two judges appointing by the crown, and it was made a king's court rather than a company court. The court held jurisdictions over His Majesty's subjects. However, the Supreme Courts were established. Supreme Courts were established in Madras first and in Bombay later. Judicial system during the periods consists of two systems: the Supreme Court in the presidencies and the central courts in the province, while the former followed the English law and procedure. The latter followed regulations law and personal laws. Subsequently, these two systems were merged under the High Courts Act of 1861. This act replaced the Supreme Court and the native courts Sadar Diwani Adalat and Sadar Nizamat Adalat in the presidency towns of Calcutta, Bombay, Madras with high courts. The highest court of appeal, however, was the Judicial Committee of the Privy Council. At the stage of development of the Indian legal system, we see in the beginning of a new era in the emergence of unified court system. The Federal Court of India was established in Delhi by the Act of 1935. It was to act as an intermediate appellant between the High Court and the Privy Council regarding matters involving the interpretations of the Indian Constitution. In addition to the appellate jurisdictions, the Federal Court has advisory as well as original jurisdiction in certain other matters. These courts continued to function until 26 January 1950, the day independent India's constitution was implemented. This Supreme, the entire judication has been divided into three tiers. At the top three, at top there is a Supreme Court. Below it is the High Court, and lowest rank is occupied by Session Court. The Supreme Court is the highest court of law. Basically, India in the world, the Supreme Court is the highest court of law. The Constitution says that the law declared by the Supreme Court shall be binding on all small courts within the territory of India. Below the Supreme Court, Below the Supreme Court, the High Courts are located in the states. Under each High Court, there are district sessions courts, subordinating courts, and courts of minor jurisdictions, that is called small cause courts. Given the importance of the judiciary in a federal system resting on limited government, the Supreme Court was designed to make it final authority in the interpretations of the Constitution. While framing the judicial provisions, the Constitutional Assembly gave a great deal of attention to such issues as the independence of the courts, the power of the Supreme Court, and the issues of judicial review. 1 minute. Compositions and appointments. The Supreme Court consists of the Chief Justice of India and not more than 26 other judges. When the Supreme Court was inaugurated, it has only 8 judges. Its strength has risen to 26 judges. The President of India, who is the appointing authority, makes this appointment on the advice of the Prime Minister and the Council of Ministers. The Constitution stipulates in Article 124 that the President shall appoint judge of the Supreme Court after consulting other persons beside taking the advice of his ministers. In the case of the Chief Justice of India, the President shall consult such judges of the Supreme Court and the High Courts as he may deem necessary in spirit of the clear constitutional provisions. The appointment of the Chief Justice of India has become a matter of political controversy. Here it may be worth recalling the issue that were raised in 1973 when the government of India appointed Justice S.S. Ray as the Chief Justice of India, sur- uh, superseding for other judges against the recommendation of the outgoing Chief Justice. SMC avoiding political interference in the appointment of judges of the Supreme Court, some important qualifications have been set for the post, such as a person should be a citizen of India, a judge of the High Court for at least 5 years, or should have been an advocate of High Court for at least 10 years, or a distinguished jurist in the opinion of the President of India. The collegium system of appointment of judges is unique in nature. It is also popularly referred to as judge selecting judges. This system was created by two judgment of Supreme Court in 1990s. In 1990s, in this, a body of senior apex court judges are responsible for appointment and transfer of judges of the Supreme Court and High Court. Tenure only once appointed a judge hold office under the attained 65 year of age. A judge of the Supreme Court may resign his office or may be removed in case of misbehavior or incapacity according to the procedure laid out in the Constitution. Each House of the Parliament will have to pass a resolution supported by two-thirds of the members present and voting. The device to remove a judge in known as impeachment, the, no, the motion of impeachment against a judge was tabled in Parliament for the first in 1991. It involved Supreme Court judges V. Ramaswamy when an audit report revealed several irregulation committees by the judge during the tenure as the Chief Justice of Punjab and Haryana High Court. A three-man judicial committee was set up with a several and a retired Supreme Court judge and the Chief Justice of Bombay High Court. The committee concluded that there had been indeed been a willful and gross misuse of political official position and intentionally and habitually extravagance at the cost of the public interest, which amounted to the misbehavior. Justice V. Ramaswamy was the first judge of the Supreme Court against whom impeachment proceedings were initiated. Justice Ramaswamy, however, maintained that there were procedural irregularities in the notice of the motion, the constitution of the committee, and its functioning. The impeachment motion, which was moved in May 1993, failed with the 196 out of 401 voting for it and remaining 205 abstaining. However, the judge eventually resigned. Salaries, a very important element that determine the independence of the judge is the remunerations received by them. The salaries and allowance of the judges are fixed high to secure their independence, efficiency, and impartiality. Besides the salary, every judge is entitled to a rent-free official accommodations. The Constitution also provides that the salaries of the judges cannot be changed to their disadvantage aspects in times of financial emergency. Only in the financial emergency, the salary, the wages can be deducted. Otherwise, don't. The administrative expenses of the Supreme Court, the salaries, allowance, etc. of the judges are changed on the consolidated funds of India. Immunities to immunities to shield judges from the political controversies. The Constitution grants them immunity from criticism against decisions and actions made in their official capacity. The court is empowered to initiate contempt proceedings against those who impute motives to the judge in the discharge of their official duties. Even the parliament cannot discuss the conduct of the judge except when a resolution for a removal is before it. The jurisdictions of the Supreme Court, Article 141 declares that the law laid down by the Supreme Court shall be binding on the all courts within the territory of India. The different categories into which the jurisdictions of the Supreme Court is divided are follow: original jurisdictions, appellate jurisdictions, advisory jurisdictions, and review jurisdictions. Original jurisdictions. The Supreme Court has originally jurisdictions initially as a federal court. In a federal system like India, both the union and the state governments derive their powers from and are limited by the same constitution. Difference of interpretation of the union states distribution of power or conflicts between states government require authoritative resolution by a judicial organ independent of both level of government. Under Article 131, the Supreme Court is given executive jurisdictions in a disputes between the union and the state or between one state and another or between a group of states and others. When we say that the Supreme Court has an executive jurisdictions, we mean that no other court in India has the power to entertain such disputes. Similarly, the original jurisdictions of the Supreme Court will mean that the parties to the dispute should be units of the federation. Unlike the Supreme Courts in Australia and the United States, the Indian Supreme Court does not have original jurisdictions to decide disputes between residents of different state or those between a state and the resident of another state. The Supreme Court also has an extended original jurisdictions as the protector of fundamental rights. As you have read in the Unit 5, Article 32 of the Constitution gives citizens to the right to move the Supreme Court directly from the enforcement of any of the fundamental rights enumerated in Part 3rd of the Constitution. Now, as the guardians of fundamental rights, the Supreme Court has the power to issue writs such as habeas corpus, quo warranto, provisions, certiorari, and mandamus. Habeas corpus is a writ issued by the court to bring before the court a person from illegal custody. The court can decide the legality of detentions and release the person if the detention is found to be illegal. By using the writ of mandamus, the court may order the public officer to perform their legal duties. Provisions is a writ to prevent a court or tribunal from doing something in exercise of its authority. By the writ of certiorari, the court may strike off an order passed by any official of the government, local body, or a statutory body. Quo warranto is a writ issued a person who authorities occupies a public office to step down from the office. In addition to issuing these writs, the Supreme Court is empowered to the issues appropriate direction and order to the executive. Appellate jurisdictions. This is a second part of jurisdiction. Name is appellate jurisdictions. Appeal court. Basically, this is an appeal court. The Supreme Court is the highest court of appeal from all courts in territory of India. It has comprehensive appellate jurisdictions in cases involving constitutional issues, civil and criminal cases involving specified therefore values of the property or a sentence, and wide-ranging power of special appeals. Article 132 of the Constitution provides for an appeal to the Supreme Court from any judgment or final order of a court in civil, criminal, or other proceeding of High Court. If it involves a substantial question of law as the interpretations of the Constitution, the appeal against depends upon whether the High Court certified, and if does not, the Supreme Court may grant special leave to appeal. Article 133 of the Constitution provides that an appeal in civil cases lie to the Supreme Court from any judgment, order, or civil proceedings of a high court. This appeal may be made if the case involves a substantially question of law of general importance or it is the opinion of the High Court. The said questions need to be decided by the Supreme Court. Advisory jurisdictions. Third one is advisory. Basically, they can court given the advisory to a government and president, basically to the president of India. The Supreme Court is the vested with the power to render advisory opinions or any questions of fact or the law that may be referred to it by the president. The advisory role of Supreme Court is different from ordinary adjudications in three senses. First is there is no litigations between two parties. Second, the advisory opinion of the court is not binding on the government. Third is, and finally, it is not acceptable as a judgment of the court. The practice of seeking an advisory opinion of the Supreme Court helps the executive to arrive at the sound decision on important issues. At the same time, it gives a soft option to the Indian government on some political difficult issues. Review jurisdictions. The Supreme Court has the power to review any judgment pronounced or order made by it. It means that the Supreme Court may review its judgments order. The Supreme Court in India is far more powerful than its counterpart in the United States of America. The American Supreme Court deals primarily with the cases which arise of the federal relations or those relation to the constitutional validity of laws and treaties. Apart from interpreting the Constitution, the Indian Supreme Court functions as the court of appeal in the country in matter of civil and criminal cases. It can entertain appeals without any limitations upon it. Decisions not only of any courts but also of an tribunal within the territory of India. The advisory jurisdictions of Indian Supreme Court also is something absent from the preview of the American Supreme Court. Despite these powers, the Indian Supreme Court is creature of the Constitution and depends on the Constitution of these powers on the union legislatures, which can impose limitations on them by amending the Constitution. Moreover, all these powers can also suspend it or supersede it whenever there is a declaration of emergency in the country. The High Court. The constitutions provide a high court at the apex of the state judiciary. Chapter 5 of Part 6 from Articles 214 to 231 of the Constitution of India contains provisions regarding the organization and function of the High Court. By the provisions of Articles 125, which say there shall be a High Court for each state, and these courts have a constitutional status. The Parliament has the power to establish a common High Court for two or more states. For instance, Punjab and Haryana have a common High Court. Similarly, there is a one High Court for Assam, Nagaland, Mizoram, and Arunachal Pradesh. In the case of union territories, the Parliament may by law extend the jurisdictions of a court to or exclude the jurisdictions of a high court from any union territory or create a high court for a union territory. Basically, Delhi, Madras, even when it was a union territory, had a separate high court, while this high court had been having jurisdictions over Pondicherry, Kerala High Court over Lakshadweep, and Bombay High Court over Dadar and Nagar Haveli, and Kolkata High Court over Andaman and Nicobar Island, the Punjab Haryana High Court over Chandigarh. Composition of the High Court. Unlike the Supreme Court, there is no minimum numbers of judges for the High Court. The president from time to time will fix the numbers of judges in each High Court. This Chief Justice of High Court is appointed by the President of India, is consulting with the Chief Justice of India and the governor of the state, which is actually term mean the real executive of the state. In appointing the judges and president is required to consult the Chief Justice of the High Court. The constitutions also provides for the appointment of additional judges to cope with the work. However, these appointments are temporary, not exceeding 2 years periods. There is also a provision for direct appointment of judges of Supreme Court and High Court through the collegium system, in which senior judges of apex court select or recommended the names for appointment of judges. A judge of high courts normally holds office until they attain the age of 62 years. He can vacate the seats by resigning, by being appointed a judge of the Supreme Court, or by being transferred to any other high court by the president. The president can remove a judge on the ground of the misbehavior or incapacity in the same manner in which a judge of the Supreme Court is removed. Jurisdictions. The original jurisdictions of High Court includes enforcement of fundamental rights, settlement of disputes relating to the election to union and states legislature, and jurisdictions over revenue matters. Its appellants jurisdictions extend to both civil and criminal matters. In civil matter, the High Court is either a first appeal or a second appeal court. In criminal matters, appeal from decisions of a sessions judge or a additional sessions judge, where a sentence of imprisonment exceeds 7 years, and other specific cases other than petty crimes constitute the appellant's jurisdictions of a High Court. In addition to these normal, ordinal, and appellant's jurisdictions, the Constitution vested the High Courts with four additional power. These are the power to issue writs or order for the enforcement of the fundamental rights. Interestingly, the writ jurisdictions of a High Court is larger than that of the Supreme Court. It can not only issue writs in cases of infringements of fundamental rights, but also in cases of an ordinary legal rights. The power of super independent over all other courts and tribunals except those dealing with the armed forces. It can frame rules and also issues instructions for guidance from time to time, with directions for splitters and effective judiciary remedy. Third one is the power to transfer cases to itself from subordinate courts concerning the interpretations of the Constitution. The power to appoint officials and servants of the High Court. The certain cases, the jurisdictions of High Courts is restricted. For instance, it has no jurisdictions over a criminal and no power to invalidate a central act or even any rule, notification, or orders made by any administrative authority of the union government, basically union territory, whether violations of fundamental or not. Subordinate, what is subordinated case courts? We discuss now what is subordinated courts. This is the third pillar of court system in India. Number one is and top is Supreme Court, second is and middle is High Court, and third is subordinate courts. We can say lower courts. Under the High Courts, there is a hierarchical of courts which are referred to in the Indian Constitution as subordinate courts. Since these courts have come into existence because of enactment by the state government, their nominals and designations differ from state to state. However, this is a uniformity regarding its original organizational structure. The state is divided into districts, and each districts have a district court which has an appellate jurisdictions in the districts. Under the districts court, there are the lower courts such as the additional courts, sub courts, courts, magistrate courts, court of special judicial magistrate of the second class, court of special judicial magistrate of one class, court of special magistrate for Factories Act and labor laws, etc. At the bottom of the hierarchy of the subordinate court, there are the Panchayat courts, Nyaya Panchayat, Gram Panchayat, and Panchayat Adalat. These are, however, not considered as courts under the purview of the criminal court's jurisdiction. The principal function of the district courts is to hear appeals from the subordinate courts. However, the courts can also take cognizance of ordinary matters under special court status. For instance, the Indian Succession Act, the Guardian Act, and Wards Act and Land Acquisitions Act. The Constitution ensures the independence of the subordinate judiciary. Appointment of the district courts are made by the governor in the consulting with the High Court. A person to be eligible for appointment should be either an advocate or a leader of 7 years standing or an official in the service of the union or the states. Appointment of persons other than the district judges to the judicial service of a state is made by the governor is accordant with the rules made by him in that behalf after consultation with the High Court and the State Public Service Commission. Now, what is judicial review? In modern time, in contemporary time, judicial review is the most powerful amendment to in judicial system in Indian judicial system. The notion of judicial review means the revision of the uh, decree or sentence of an inferior court by a superior court. Judicial review has a more technically significance in public law, particularly in countries having a written constitution founded on the concept of limited government. Judicial review in this case means that courts of law have the power of testing the validity of legislation as well as other governmental actions considering the provisions of the constitution. In England, there is no written constitution. Here, the parliament exercise supreme authority. The court do not have the power to review laws passed by the sovereign parliament. However, English courts review the legality of executive actions in the United States. The judiciary assumes the power to scrutinize executive actions and examine the constitutional validity of legislation by the doctrine of due process. By considered in India, the power of the court to declare legislative enactments invalid in explicitly enact in the constitution. Fundamental rights enumerated in the constitution are made justiciable, and the right of constitutional remedy has itself been made a fundamental right. The Supreme Court power of judicial review extend to constitutional amendments as well as to other actions of the legislature. The executive and the other governmental agencies, however, judicial review has been particularly significant and continuously regarding constitutional amendments under Article 368. Constitutional amendments could be made by the Parliament, but Article 13 provides that the state should not make any law which takes away or abrogate fundamental rights. And they, one second. the the issue is, would the amendment of the constitution be a law made by the state? Can such a law infringing fundamental rights be declared unconstitutional? It was a riddle before the judiciary for about 2 decades after India became a republic. In the early years, the courts held that a constitutional amendment is not law within the meaning of Article 13 and hence would not be held void of its violates any fundamental rights. But in 1967, in the famous Golaknath case, the Supreme Court adopted a contrary positions. It was held that a constitutional amendment is a law and it that amends violated any of the fundamental rights, it could be declared unconstitutional. All formal amendments that uh, violated the fundamental rights to property were found to be constitutional unconstitutional. When a law remains in force for a long time, it establishes itself and is observed by the society. It also past amendments are declared invalid in the number of transactions took place in pressure of these amendments become unsettled. Now moving on to in the early years, the courts held that a constitutional amendment is not law within the meanings of Article 13 and hence would not be held void of its violated any fundamental rights. But in 1967, in the famous Golaknath case, the Supreme Court adopted contrary position. It may held that a constitutional amendment is show a law and it that amends violated any of the fundamental rights, it could be declared unconstitutional. All formal amendments that violated the fundamental rights to property were found to be unconstitutional. Now, what is the judicial reforms? We discussed judicial reform. While the judiciary have earned respect from its contribution to protecting citizens from arbitrary exercises of power, a large number of pending cases and the delay in the dispensations of justice are seen as its major drawbacks. All at the All India Seminar on Judicial Reforms in August 2010, the Chief Justice of India, S.A. Kapadia, point out that there are over 1 crore cases pending from more than 1 year. A reason for the pilling of a large number of cases can be attributed to structure and procedural flaws in the judiciary. The availability of multiple remedies at different rungs of the judicial ladders also enables dishonest and recalcitrant suitors and to abuse the judicial system. It leads to the piling up of cases as well as a delay in the dispensations of justice. Now, let's sum up. Before it, we complete this unit number 8, unit number 9, and unit number 7 related to government, government part of India. Basically, they are the three branches of government. They are the three pillar of government. Number one is legislature. We are discuss in unit number 7 and unit number 8. We discuss about executive power, and unit number 9 basically related to judicial system, yeah, justice system in India. This unit name is judiciary. And we discussed there are four pillars in judiciary system. Basically, we discussed in basically mainly three pillars. Number one is Supreme Court, second is High Court, and third one is subordinate courts, basically district courts. And under some district courts, there are several branches of courts in India. This is a system in Indian judicial system to give a justice to all Indian citizens and resolve all the disputes between union and states government. Now, there are subordinate courts. Name is under the district court. There are the lower courts such as the additional district courts, sub courts, municipal magistrative courts, courts of special judicial magistration of the second class, court of the special judicial magistration of the first class, court of special municipal magistrator for the factory acts and labor laws, etc. There is the provision, there is the structure of India of district court. Now, let's sum up. As we saw in this unit, the existing judi- judication in India can be traced to the British period, the Regulating Act of 1773, the Indian High Courts Act of 1861, and the Act of 1935 are the important milestone in the evolutions of the modern judicial system in India. According to the Constitution of India, the Supreme Court is the highest court of law. The law declared by the Supreme Court has been made binding on all small courts, that is the high courts and subordinating courts. Given the importance of judiciary as a federal court and as a guardian of fundamental rights of the citizens, the farmers of framers of the Indian Constitution gave a great deal of thought to such issues as the independence of the courts and judicial review. Judicial review is the techniques by which the courts examine the actions of the legislature, the executive, and the other governmental agencies and decide whether or not these actions are valid and within limits set by the Constitution. The fundamentals of judicial review that the Constitution is legal instrument, B is that is law is superior in status to the law made by the legislature that is itself set up by the Constitution. It is now well established in India that judicial review constitutes the basic structure or feature of the Constitution of India. Now, this unit is completed, and we discuss about three branches of Indian political system. Number one is executive, legislative, then executive, and third one is uh, judiciary. And you can discuss, you can learn, and you can know about these units, and you can know about these topics. Till now, we meet again in next class. Namaste.